Judge Wilson, that appears to be everything on my docket, and I did get the Munoz continuance. So if it's okay with you, I'm going to sign off.
That's fine. Thank you.
Thank you, Judge.
Okay. Where do we stand?
So you're,
Right. I think we
motion.
go forward with the argument on the team.
Okay. Let's take about a 5-minute break. I'm waiting on a search warrant that I need to sign, and I'll come back at 11:30 and we'll get started then.
Okay, thank you, Your Honor.
Have to walk that mail down before. Why don't you do that now, because he's going to hear us at 11:30.
All right, give me a moment. Let me just sign this search warrant and affidavit, and I will get started. Okay, do I need to look at the actual motion for continuance before we get started, or?
It's certainly on file, Your Honor, and lays out in some detail, and I can go through some of that at the hearing if you'd prefer, but if you'd like to glance through the motion, that certainly would be helpful and appropriate.
All right, can someone just post that to me in chat?
Yeah, let me see if I can do that.
And Your Honor, the 10 groups of defendants filed a response. If it pleases the court, can we upload the response?
Certainly, certainly.
Oh, hold on, looks like I have to save it to my hard drive before I can upload it.
And Your Honor, for the part of the defendants, the plaintiffs came on a 15-minute announcement. And I think there's collectively 30 pages of briefing. Given that this is just a continuance of a summary judgment hearing, I think the court could probably save some time getting through 30 pages of briefing, but obviously whatever pleases the court is perfectly good.
All right. What sort of case is this?
Yes, Your Honor.
It's an oil and gas case.
It's an oil and gas royalties case seeking to enforce term royalties that were sold to my client's predecessors that we believe are still in force. And so we're seeking to enforce term royalty interests.
Okay, and what is the scope of the motion for summary judgment?
Yes, Your Honor, there were 8 motions for summary judgment that were set on 21 days notice at 4:58 p.m. on January the 5th. And we have corollary mirror image motions on a number of those. And so we had first filed motions that we had sought to set at the same hearing because they're mirror images of each other. And so I can go through that with, I've got just a few PowerPoint slides.
Well, I take it from the number of folks here that this would be dispositive of all or much of the case, at least as far as liability.
Yes, Your Honor.
Okay, it's not just some little technical issue. All right. And are there companion motions then that are not set at the same time?
That's the problem, Your Honor. Yes, there are companion motions that should be set at the same time, but because of the lack of coordination, that was not done. And so we're seeking a continuance of the January 26th hearing so that the court can hear and consider the related motions in connection with the same hearing, both to avoid the risk of inconsistent rulings, but also just for judicial economy and efficiency.
Your Honor, may I be heard briefly?
Yes.
At paragraph 20 of the plaintiff's motion for continuance, they concede that 5 of the 8 motions
No.
do not pertain at all. And I can quote it directly to the court. This is what they filed to the court at paragraph 20. 3 of those motions cover the issues addressed in plaintiff's motions and duplicate issues raised in the motions filed by Sierra Bank, Cirrus Minerals, Mustang Minerals, and EOG. The preceding sentence noting that there's 8 motions filed. The motion that they now say they want a hearing on was filed by them in April of 2020. So 8 months ago.
No.
The only reason that they moved forward on saying anything about a hearing setting on that motion after 8 months of intentional delay is that the defendants.
All right, one at a time. Go ahead, Mr. Wiemeyer.
Thank you, Your Honor. They filed a motion in April of 2020. They've had 8 months to have a hearing on that. We didn't ask for cross motions to be heard. We didn't ask for more time. We didn't say we needed a continuance. He was free to have that heard at any point in the last 8 months. We filed 8 motions on the deadline that he agreed to in the scheduling order and that this court entered. And at paragraph 20 of his motion, he only says 3 of them overlap with his. I would suggest that given that we have all 10 of these sets of defense counsel and Mr. Kilday has acknowledged that everybody in his office is available on January 26th for that hearing, that we go forward on at least the 5. And if he thinks that there's some other issue as to the 3 that overlap, according to him, as to his motions, those could be taken up on February 8th and 9th. But given the numerosity of counsel and schedules and the court having very valuable time, we need to make use of the January 26th setting. And it is a matter of law. So if either we're entitled to the relief, the summary judgment relief, or we're not, there's no motion that he has that bears on whether we're entitled to our matter of law relief. He will file a response to our motion. He's entitled to whatever time frame under the rules that he's entitled to respond. He fusses over 21 days, and I want to make sure this is very clear. We filed these motions back on December 18th. So it's not like he had the bare minimum of notice. On December 18th, we asked, hey, we filed our motion. We'd like to have a hearing today. He responds with a number of self-serving. He wants a briefing schedule. He wants more time. He wants it done in February. He wants cross motions. And
let me ask, how long would it take to hear all of these motions you expect from both sides? If they're all heard?
With respect to our 8 motions, I mean, really, it's really, could take 2 days of hearing. These are currently on Judge Ellison's docket for hearing, and the other dates discussed being February 8th and 9th. I think realistically, it's probably at least 2 full days of hearing if all of the motions are being taken up. But at least as to the 5 that Mr. Kilday concedes, I think we can get that done within the 2.5-hour announcement that's currently on the Judge Ellison's January 26th docket.
All right. And Ms. Riley, I just wanted to verify, because when I look at the calendar, it says on that date, no more settings, but that's because of this case?
Yes, Your Honor.
Your Honor, this is our motion for continuance. I'd like to be heard.
All right. And let me just ask, if I'm trying to get my coordinator's office. Lori, are you there? Okay. All right, I guess not. Because this may be an add-on. It doesn't show, but there's actually a docket for Karnes County on that date. But it may be that it was set in front of Judge Ellison. Okay, go ahead, Mr. Kilday.
So, Your Honor, we have I've shared the file with our motion for continuance, and if possible, I'd like to share screen and just go click through a few PowerPoint slides, if that'd be okay with you.
Go ahead.
Okay. Okay, so this is what the case is about, Your Honor, briefly. I don't want to get too far into the weeds, but there's a tract in Karnes County just southeast of Gillette known as the Frells Tract that's about 490 acres. And you can see on this plat that it's a large rectangle. And then there's a piece of the tract that goes off to the left. It's a road that's part of the Frells Tract. And that road is included within a pooled unit. There are 25 plaintiffs in this case, all represented by our firm. Those plaintiffs are all the successors in interest to term royalties that were granted in the 1960s. And those royalties are to be in effect for a term of 15 years and for as long after the expiration of that term as there is production in paying or commercial quantities. So we represent all the plaintiffs in this case, seeking to enforce those term royalty interests. There are 13 defendants. One is the operator of current horizontal drilling, EOG resources, and the others are mineral interests that we believe are burdened by the term royalties. Those 13 defendants are represented by 10 different law firms. And the motions that have been set are motions that were set by DDR Gaddy and Stephen Bressler. There are 8 separate motions that were filed on the last day of the third scheduling order in mid-December. So going back to the Frells tract, Your Honor, there are 2 wells on that tract that we maintained perpetuated the term royalties that are owned by our clients. One you can see is on the rectangular portion of the Frells tract. That well operated and produced, we believe it produced in paying quantities until 1997, when it was plugged and abandoned. The other well is very close to the property line of the Frells tract, but is just off that property line. It's located on a tract known as the Schnitz tract, which is part of a pooled unit with the Rydell tract and a 1.85 acre portion of the Frells tract. This is known as the Schnitz-Rydell unit, and this well continued to produce until 2014. EOG's new wells began to produce in March of 2014. The Schnitz-Rydell unit well continued to produce until June of 2014, and that's not disputed, but there are disputes about, was that production in paying quantities? That would be a fact issue. Both sides have experts. And then there are a number of issues that have been raised by the defendants about whether the nature of that production was such that it should count as unit production, or whether instead that was simply lease production for the benefit of only the Schnitz tract. And we have filed motions for summary judgment on those issues because for the entirety of those decades, the production from that well was treated as unit production, not lease production. It was reported that way to the Railroad Commission, and the royalties were paid that way, both to plaintiffs and their predecessors, and also to defendants and their predecessors. So our motions are more in the nature of quasi-estoppel, ratification, waiver, statute of limitations, and the defendants have motions about the technical details about whether this ceased to be lease production, ceased to be unit production and became lease production back in 1972 or 1992, or at the time when there was a release of the Frells lease. So that's just a glimpse of the issues without getting too far in the details. That's what we're arguing about. We did file one of our motions back in April on the issue of whether or not the production after 1992 continued to be unit production as it was treated and as it was paid. But we also filed another summary judgment motion in September on a whole host of issues. And we believe 6 of the issues in the DDR Gaddy Bressler motions are either mirror images of our issues or are very closely substantially related to the issues we've raised. We did not set those for hearing, not for delay, but because the defendants had told us they intended to file summary judgment motions of their own, and we knew that the court would need to hear these in conjunction with each other. So moving on to the summary judgment motions and the setting on the 26th, there are 3 motions that the plaintiffs have filed for summary judgment. There have been a separate motion on some of the same issues I've just discussed, filed by defendants Sierra Bank, Cyrus Minerals, and Mustang Minerals. There was another motion for summary judgment filed by EOG Resources on the issue of the release of the lease. And then on December 18th, there were 8 motions for summary judgment filed by DDR Gaddy and Bressler, again on the very last day of the third scheduling order. So what are the requirements of Karnes County local rules for this court, for the 81st and the 218th? The local rules clearly require that prior to requesting a setting, the council shall attempt to coordinate a setting with opposing counsel. It doesn't say send an email and stop, it says coordinate. And then local rule 4 also says that all requests for a setting shall include an estimate of the amount of court time required for the hearing. Here, there was a failure, no meaningful attempt to coordinate. There was a single sentence email that was sent on the afternoon of December 18th. And I want to just note for the court, at the time this email was sent to me, only one of the 8 motions by DDR Gaddy and Bressler had even been filed. The other 7 followed this email late into the evening on the 18th. So it wasn't clear what was even being requested, what setting was being sought, which motions were to be set. It was simply tell me what dates you're available for a summary judgment hearing. I responded the very next business day with an email to, I thought it was to all counsel, but it was to all counsel that were included on John Ellis's email to me. Apparently Gary Ellison was not included, but I attempted to coordinate and noted that the plaintiffs, the motions are generally address issues covered by our previously filed motions. We'll be setting our first filed motions for hearing as well. The court will need to hear and consider them together. What are your thoughts on a realistic time announcement? Knowing that the local rules require a time announcement, how do we handle that with 10 different groups of defense lawyers? So what's a reasonable time announcement for all motions and all parties? Will 3 hours be enough, or will more time be needed? We'd like to discuss an agreed briefing schedule. I sense there's resistance to that, but I've certainly done that in a number of state court cases, and it's been helpful to the court and all parties to have a briefing schedule with a known date for reply briefs so that people don't get blindsided at the hearing. That would need to be done by agreement, but I tried to coordinate on that. And then please discuss the time announcement issue and the briefing schedule on the defense side, and then let's set up a call to discuss those issues, as well as the hearing date. So that was my email the very next business day. This was the week of Christmas. I didn't necessarily expect that there would be a response right away because people are going to scatter for eggnog and the holidays, but I sent this communication and there was no response. I still didn't get a response to that email. Instead, I got a unilateral notice of hearing served at 4:58 p.m. on January 5th, 21 days exactly before the hearing date that was unilaterally selected by the defendants. It did appear they coordinated with each other, but not with us. That notice of hearing was served as the court offices were closing. So it was not possible for us to even to attempt to set our motions at the same time. And it was a notice of setting of only the DDR Gaddy Bressler motions, not the EOG motion. One of the DDR Gaddy motions is a joinder in the Sierra Bank motion, and it appears they've attempted to set that one for hearing as well, but Sierra Bank has not separately sought to set their motion for hearing at that time. And there was no coordination on the time announcement or on the hearing date, despite our request, even though it does appear the defendants coordinated with each other, because as soon as this issue was raised, all of the defense counsel responded very quickly saying, we're available on the 26th, we're available on the 26th, but that was not coordinated with us. And those efforts to coordinate on resetting were rejected. I've shown the court exhibits A and B to our motion. Exhibits C and F were in the immediate aftermath of that, where we attempted to discuss opportunities to reset it for an agreed date and time where these motions could be heard and considered together, and those efforts were rejected. So there's an allegation by the defendants that this would inject some sort of delay, that this is some sort of delay tactic by us. And I want to just submit to the court, that's absolutely a red herring. The DDR Gaddy and Bressler defendants waited until the last day of the third scheduling order to file their 8 motions for summary judgment. So if there is any delay, that's on them, not us. And then they waited 2 weeks before the expiration of the third scheduling order before even scheduling and taking their very first deposition in this case. This case was filed in August of 2018. And so more than 2 years passed before the defendants took their first deposition in this case. We had taken a deposition in August of 2019, and then these other depositions requested by the defendants were at the 11th hour on the third scheduling order. And then Gaddy and Bressler waited until 4:58 p.m. as noted, 21 days before the hearing, before giving notice of their hearing. This is not, Your Honor, coordination as required by the local rules. It's not conferring as required by the Texas Lawyers Creed, which is incorporated into Karnes County's local rules. This is an ambush. And it's a cram down, and it's an attempt to deprive the court and the parties of the opportunity to brief and argue and have the court hear and consider and decide motions on identical or mirror image issues at the same time or in connection with the same hearing. And that's what we've asked for. And it's not just 3 as indicated in the motion. We've looked at it all more closely, and there's 6 different motions by DDR, Gaddy, and Bressler that are on the same issues as our second motion for summary judgment and our first motion for summary judgment. The third is on disposing of a number of affirmative defenses. That one certainly could be heard separately, but those 6 issues in DDR, Gaddy, and Bressler's motions are on related issues. So we believe a continuance is necessary. We need additional time to properly respond to 8 new summary judgment motions on a case that's been pending 2.5 years with complex issues and a number of parties. The bare minimum of 21.
And I'm sorry, I need to break this for a moment.
Yeah.
Yes, Detective. Okay, I'm back. Do a search warrant, swear to it over the telephone now.
Thank you, Your Honor. I'm wrapping up. So may I proceed?
Yes, sir.
Okay, so one motion is a no evidence motion on all of plaintiff's claims, which will require the marshaling of evidence and putting it in a form of affidavit rather than simply having witnesses testify at trial. And that's going to take some time. So we need additional time just based on the the complexity and the details of the various motions. As noted, judicial economy and efficiency would dictate that these should be heard together. There's a requirement to coordinate that was not followed. And then Mr. Waymeyer's talked about conflicts. We've identified conflicts. My partner, Mary Cnty, who will be participating with me in arguing these motions, as well as in preparing the briefing. She has an appellate argument 2 days after this scheduled hearing, a case Mr. Ellison is involved in, and she'll need time that week to be preparing. She's taken the lead on arguing that appellate argument 2 days after this scheduled summary judgment hearing. And then I had reserved that date for an out-of-state deposition in a multi-party case pending in Travis County, where the lawyers actually had been coordinating and talking to each other as we're supposed to do on setting things. And we had reserved that date and parked it pending the delivery of a notice. And I had to renege on that because of this summary judgment hearing that was set. And so I have now backed out of that, but that was a commitment on my calendar to keep that date reserved for an out-of-state deposition of a former employee of our client who now lives in Washington, D.C. So there was a conflict at the time when this was set. So the relief we're requesting, Your Honor, is a continuance of the January 26th hearing so that we can coordinate on a setting. We want the hearings reset in February with all related motions heard at one time, or at least in connection with each other. If we need more than 3 hours, we can break them up and have two settings where those motions will be heard on back-to-back days if needed. And we want the new setting to be at least 21 days out so all parties can give proper notice of that hearing. That's a relief we're requesting. I'm happy to answer questions from the court. I'm also happy to respond to any arguments made by the defendants. Thank you, Your Honor.
Turner, may I be heard?
Yes.
Thank you, Your Honor. And I think what you just saw was is an example of what the defendants in this case have been dealing with. There was a 15-minute announcement out of plaintiffs for today's hearing, and Mr. Kilday spent in excess of 15 minutes in his argument alone arguing the merits of the case. Let me start with the local rules. The local rules require conferral, and if unsuccessful, you proceed with setting the hearing. In this case, we asked for January dates. Mr. Kilday will never give us a January date for summary judgments because he wants more time. Here's what's important about the more time remarks during his oral argument today. There is nothing in the conferral correspondence, which spans over half a dozen emails trying to coordinate on the hearing date, where he says we need more time for briefing. He has never once taken the position that he just can't be ready because he doesn't have enough time to prepare the briefing. That was for the first time urged today during a oral hearing. With respect to the motion for continuance, what the local rules in Karnes County do require is that he satisfy Rule 251, 252, and 253 of the Texas Rules of Civil Procedure if he comes to this court asking for delay's sake. That's contained at Local Rule 1.2, subsection B. He doesn't say anything in his motion that justifies any continuance under Rule 251, 252, or 253 whatsoever, not the least of which being that he doesn't say in the motion that he doesn't seek delay for delay's sake, but so the justice may be done. With respect to the 26th, here's what we know about the 26th. Every single one of the defendant's lawyers is ready to go, has that on their calendar, and can be heard on a dispositive matter that day. Here's what we also know. Of the 4 lawyers that are on Mr. Kilday's pleadings in this case, all 4 of them have no conflict whatsoever on January 26th. With respect to Ms. Cnty, what she says, she's played zero visible role in this case, other than her name showing up on filed papers as an additional counsel. She's done nothing in the case and she's not on the hearing today. The fact that she has a hearing on the 28th in some other matter and would rather spend the 26th attending to that, if that's the standard for a continuance in this court, we could never have anything heard, period. We asked Mr. Kilday, give us January dates. He wouldn't do that. We asked him on January 26th, what is the conflict you allege? He had none. And so we proceeded forward with insisting that the hearing go forward on matters of law. If Mr. Kilday is correct in his remarks that he has already briefed these issues pertaining to our motions, then it should be no problem for him to respond with respect to the 26th. According to him, the briefing's all done because he's already briefed it in the first place. But I would step back and say, the idea of 21 days, he's had these motions since December 18th. We have trial currently set for March 22nd. We have pretrial deadlines. We have Robinson deadlines. We have other matters that need to be heard besides just summary judgment. If he wanted motions for summary judgment to be filed earlier, at some point before December 18th of 2020, he could have asked for that in the scheduling order. He should have and was required to ask for that in the scheduling order. And so we never told him we were filing any motions for summary judgment. I would love to see the sworn statement from Mr. Kilday where I told him I'm filing a motion for summary judgment and I'd like them to be heard at the same time or otherwise. This is all an after the fact manufactured excuse for more time, which he argues today, but is nowhere in the continuance record. He didn't have only 21 days notice of the hearing. He had 40 plus days notice of the hearing because he was told on December 18th, we want these heard in January. What this all comes down to is that we couldn't confer further on any date because he wasn't going to allow us to have a hearing date. He wants delay for delay's sake because now he says he wants more time to brief. The case is 2.5 years old. This comes down to pure matters of law. There's 8 motions for summary judgment. Any one of them being granted disposes of this case that's been on the court's docket for 2.5 years. My last comment on local rules. Let me say this on local rules. He says that we didn't confer, even though the uncontradicted record of exhibits A through F to his motion comprise at least 6 different email conferral efforts. But stepping back from that, he noticed today's hearing with 0 conferral, no email, no phone call, no anything. I have a summary judgment hearing today at 9:00 a.m. in Gregg County, Texas, in a case that I'm attorney in charge for Brightburn and for Maverick Oil and Gas on. And I had to make other arrangements for that summary judgment hearing to participate today because Mr. Kilday didn't even wave his hand over any conferral to ask on January 12th, are you free for a hearing or not? What did we do? We behaved professionally. We reorganized. We got here. What I say, good for the goose, good for the gander. If Mr. Kilday goes in and unilaterally notices with 0 conferral effort whatsoever, disrupting our schedule, I think it's incredibly hypocritical and utterly out of place with the local rules, Texas rules of procedure, and the scheduling order in this case for him to come in and say, well, I'm not going to confer, but I get to have my affirmative motion heard, even though it has actually created hard and fast scheduling conflicts. So here's where we're at. We've got a number of deadlines fast approaching, not the least of which being final pretrial disclosures on February 12th. We have Robinson motions and hearings coming up. And what we've presented after 2.5 years are very simple, pure matter of law points. According to Mr. Kilday, at paragraph 20 of his motion, at least 5 of those don't pertain to whatever he wants to have heard on a cross motion. At a bare minimum, consistent with the Texas rules of civil procedure, we're entitled to have those heard. And it wasn't just on 21 days notice. He's had over 40 days notice that those need to be heard. And there's not that many other dates between now and March, let alone between now and February, to take up the others. So what we would request is that we request is nothing more than the Texas rules of civil procedure be enforced here and that the court scheduling order be enforced. Why? Well, he agreed and asked this court to enter that scheduling order. With respect to the rules of procedure, it says up in Rule 1, the reason for these rules is to ensure fair administration of justice, that everybody plays by the exact same rules, that you don't play picky-choosy the way Mr. Kilday doesn't come in and setting this hearing with no conferral notice, but when we confer on the other one, delay for delay's sake. And so we would just ask the rules of procedure and the court scheduling order be enforced, that we go forward on January 26th. If he wants to set his other motions for hearing in February, I have no problem with that. We'll respond to them if we need to, and in due course. But on the 26th, Judge Elliston may decide, as a matter of law, have we proven our entitlement to judgment as a matter of law or not? Either we have or we haven't. And if he decides we haven't, I guess that bolsters Mr. Kilday's argument to come in and say somehow he has. But we would just ask for the scheduling order to be enforced. We'd ask the rules of procedure to be enforced. We'd ask that everybody operate under the same rules. And look, trial's coming up in March. We're all big boys and girls. We need to have this case ready and get this thing off the court's docket so that it can move along to its natural.
All right. And let me just ask Mr. Wiemeyer, was there any response from the defendants? I'll ask all the defense counsel To the Mr. Kilday's email, which I'm assuming he said the next business day, I assume that was December 21st. Was there any response to that?
No,
Okay, I'm asking the defense counsel.
In the January correspondence over the specific date of January 26th, there was a response. I mean, there's a continuing thread, but in terms of responding directly to the December 21st email that day or before, having concrete discussion about January 26th, no, Your Honor.
And what do you mean about having when was there a concrete discussion about January 26th?
So we noticed the hearing for January 26th on January 5th. We didn't realize that that was going to be a good date, that the court had any time until coordination with Ms. Riley. We were just saying what dates are available. We find out on January 5th that there's 2.5 hours available on the January 26th docket. We set that, and then there's multiple email correspondence. You're going to find this at exhibits C through F, plaintiff's motion, where concrete.
And I don't have the exhibits.
In those emails, basically we said, hey, look, if you have a conflict on the 26th of January, tell us what it is and we can accommodate it or discuss with our clients, but we need to know what your conflict is. And in response, what we found out was there was no conflict at all. What he wants is just more time and wants to set his motions for hearing. And so, I mean, it's never.
Okay, and will someone post to me the exhibits to the motion for continuance? Because I received the motion, but not the exhibits.
yes, Your Honor. I'll pull that and I'll post that. I sent you the Word version saved as a PDF, but I'll find the version with the exhibits and I'll reattach that in the notes. But there was no effort to communicate until after the setting had already been achieved and after 5 o'clock that day had passed. But I'll put that in the chat just momentarily.
All right. Anything else from the other defense counsel?
Yes, Your Honor. This is Marty Trust, very briefly on behalf of EOG, only because the question of a separate motion for summary judgment filed but not yet set by EOG has been raised. I've never had a contested hearing on a motion to continue in 26 years, particularly when the motions were set pursuant to the rules and no conflict with the actual hearing date has been identified. Be that as it may, EOG did file a motion for summary judgment before the last day provided for in the scheduling order. I don't know that there's anything wrong with getting motions filed on the last day before the scheduling order says you can't file them. But we filed our motion before. I did not set that because the issues raised in my motion are fairly encompassed within the DDR Gaddy motions. I did join in those DDR Gaddy motions. So it's a bit of a red herring that particular motion has not been set. I think we need to make the best use we can of January 26th. At the very least, for the matters on which there's no alleged mirroring of issues.
And all right, I'm just waiting. I wanted to look at the exhibits to the motion for continuance. Now, I will be in Kearns County the 19th of this month to try and impanel a grand jury. We're doing that in person. The Texas Supreme Court still has us under the very restrictive things that we can do in person. I don't believe it's going to be possible to pick a jury in Kearns County and try a jury trial in Kearns County under the social distancing requirements. Judge Ellison seated a grand jury in Atascosa County last week. Atascosa County generally has as good a turnout on people who are summoned to serve on the jury, the grand jury, as any county in the district. And they summoned, I was told, 175 individuals. They set up a web page with a little pixelated box, QR scans that you could scan that or go to the web page, and then you could make your COVID declaration basically if you'd been exposed, and also had a thing that said, check here if you don't want to appear because you fear getting COVID. And by the time we had people that just blew us off, got rid of the people who checked in that said they were ill, that said that they were elderly or they were in some, group of special concern with COVID, they only had, I think, 17 show up. And one was disqualified for cause. One had an excuse she could have claimed that she had young children. So they got a 12-person grand jury and 3 out of 4 possible jurors seated. And that's out of summoning 175. So if we're looking at some, what if everything is denied at the summary judgment level, what trial length would you be looking at?
I believe it's set for 2 weeks, Your Honor.
I don't see this being a 2-week trial, Your Honor. For the part of the defendants, I think it's probably 5 full days.
Okay, and I've got the exhibits now. Let me look at them. All right, anything else from either side?
From the plaintiffs, Your Honor?
From either side.
Okay, I would just respond that, as noted, we believe that 6 of these motions are mirror images or interrelated with the motions that were filed by DDR Gaddy and Bressler. The ones that are not are a no evidence motion, which is going to be the one that's going to take the most time to respond to with the marshaling of evidence. And then their 8th motion for summary judgment is the only one, I believe, that is not a mirror image of one of the motions that we have filed. The others are all included in our 1st or 2nd motion for summary judgment. So, and I will note that the only productive thing that came out of the breakout room and the chat is discussion that the 8th and 9th of February appear to be workable dates, back-to-back dates. So to the extent we need more than one setting, we could reset all motions for that time and have them heard in conjunction with one another.
Okay, and are those, have you checked with the coordinator's office about those dates?
Mr. Waymeyer indicated that they appeared to be available with the court, but no, I have not.
All right, Ms. Riley, are you on? Yes.
I am. I can tell you the 9th, you have the one case, the Peeler case, for 3 hours already.
Okay.
Well, we would certainly be willing to work with and coordinate with all defense counsel on agreeable dates. That's the dialogue I would have expected and the dialogue I'm accustomed to in my other cases. And I'm certainly happy to have that dialogue to work toward a back-to-back setting in February with 2 days if we need 2 days. I don't know exactly what time would be needed. Whenever I ask how much time would be needed for all motions, what I hear is how much time would be needed for their motions. And so I'm looking for a total time announcement. If we can get it all done in 3 hours, great. But if we need more than that, then I'd be happy to work with defense counsel on 2 back-to-back settings so we can get it all done in 2 days.
Okay, well, we're going 45 minutes on a 15-minute continuance. Anything else for the defendants?
Your Honor, this is Blue Hyatt. I've been kind of sitting back listening, and what you've just heard and what you just said is exactly the case of why we should utilize January the 26th as well. Why don't we use that 2.5 hours to set something at that point in time, utilize whatever we can on February 8th, February 9th. I mean, there are a lot of summary judgment motions and other motions that are going to have to be filed in this case. I think, and I hate to waste any court's time, especially yours, Your Honor, but it seems like we need to jump on whatever time we have available to have whatever motions we have that can be heard.
You're right.
I would be willing to go forward on the DDR Gaddy 8th motion for summary judgment on the statute of limitations on the 26th, if that helps. That's the one that's not related to one of the motions we filed. That's not a no evidence motion. So I can proceed on that one if that helps. The others I think need to be put off so they can be heard in conjunction with the mirror image motions.
Mr. Weimer, you were trying to speak?
Yes, in just 30 seconds. All the defendants here, the 10 groups of defendants are asking for is that the scheduler and rules of procedure be applied fairly and uniformly. Mr. Gilday disputed in no way, shape, or form that he set today's hearing on a day that I had a summary judgment in Gregg County with zero conferral or coordination. But here we are. I think we're entitled to go forward. If he wants to urge a not ready to Judge Ellison on the 26th, he can re-urge a not ready. We just want the rules of procedure applied uniformly and fairly.
And Your Honor, as to today's setting, I asked Ms. Riley to identify any dates that were available before the brief would be needed to be filed next Tuesday. And this was the only setting available. I also was supposed to be in attendance with something else this morning that I had to just let a client down and not be part of a group discussion with an expert witness that included about 20 people where I'm the lead lawyer on it. And so I've let another client down to be here today, but it's the only date that the court had available for this continuance hearing before the 19th.
Okay. Okay, the local rules, Rule 4, hearing of contested cases says prior to requesting the setting, counsel shall attempt to coordinate a setting with opposing counsel. And certainly that was begun in this case with the initial email, which was, I guess, filed, on the 18th. And Mr. Kilday responded appropriately, I believe. Let's get this done. And he raised some pertinent issues about things that ought to be discussed. And then nothing else happened until the case had already been set on 21 days notice. So I agree that Mr. Kilday also didn't coordinate or attempt to reach a coordination before he set this, but the defendant's offense against the local rules was first. I think it's got to be more than just you don't get a response, you get a response that says, we can have a hearing in 2028 or something. That's great. I'm not going to ask you to follow up on that. But if you get a perfectly, to me, reasonable response that raises issues that certainly need to be thought about, I think you need to do more you must do more to follow up on it before you can just unilaterally say we're at an impasse. So grant a continuance as to everything except that number 8. If it would be a better use of the attorney's time to not hear that by itself, so you can free up your mornings on the 26th. I'm more than willing to let y'all talk about that. And I'll also ask you to get with Ms. Riley on what dates would be available. It sounds like the 8th, I don't know, how much is set on the 8th already?
That's gonna be a mixed docket, Judge. Criminal, I'm not sure how many criminal cases are set, but so far I have one case set for Wilson County on the 8th.
And has Judge Ellison already heard much in this case?
He is not.
I'm not sure.
Thank you, Your Honor. And I do think, just in light of the, need more time, that if we could get a firm resetting as to the other 7 to the 8th and the 9th, that would be a good use of time. And Mr. Kilday can obviously set anything. He hasn't asked to set anything for hearing yet, but whatever he wants to set for hearing, he can add to those dockets.
Well, my December 21 email does ask for a setting and a time to set the plaintiff's motion. So we'll be seeking to set them all at the same time, Mr. Waymeyer. And so I'm happy to work with you on a 2-day block if you feel we need 2 days. So we can coordinate that with Ms. Riley, and I'm happy to work with you on that.
And Your Honor, I feel like once we lose this court audience, this is going to go back into the oblivion. And so everybody has said they're ready on the 8th and the 9th. There is some time on the docket. I would very respectfully ask to avoid us having to come back here and do this again, that while we've got all the defense counsel and plaintiff counsel ready to go on 8th and 9th, that those 7 be reset in a firm way.
Okay. And Ms. Riley, what does the 8th look like?
I'm sorry, Judge. Can you repeat that?
You said the 8th is a mixed docket, civil and criminal?
Yes, I'm asking Jennifer how many criminal cases. It's Wilson County, so that's usually pretty
This
heavy.
is Karnes County.
Yeah, this case is Karnes County.
Right, but
Yeah, but I've got 5
That's
counties, and since we're not bound by geography, I mean, the docket you set through this morning was Wilson. I've never had all 5. I've had dockets from 4 counties on a single day.
say the February 9th docket is pretty heavy already. I've already got like several cases set, and one of them is for 3 hours on that date.
What about later that week? I could do later that week as well.
She's got 22 criminal cases set on the 8th, Judge, at this time. The 10th and the 11th are, you know, they're not quite as many set at this time. I don't know about the criminal side. It is an arraignment for Atascosa, the 10th of February. I'm checking with
Those
Jennifer.
are always bad.
Yes.
Okay, let's set everything for the 8th and 9th. And I'm also going to set a conference call on Friday the 5th, just a status report at 2 p.m. And you don't have to have all your lead attorneys there. I just want everybody to have a representative to say, yes, we're absolutely doing this, because I'm going to, actually, let's make it on the Thursday at 2 p.m. because I'm going to ask the coordinator's office to try and get a possible visiting judge lined up, because it's not going to be possible ever to just find 2 full days easily. So I've got about a half a day on the Peeler case in Atascosa County on the 9th already set out.
And Your Honor, my office is telling me that 8th, 9th, 10th, and 11th are all good. So if we spread it out and use what we can over those 4 days, that's, I mean, obviously still having number 8 heard on the 26th of January, but if we spread the rest of them out, if there's anything left, I think that works for me.
I just noticed I do have another hearing set for the morning of the 11th. I may be able to find alternative coverage for that, but that's something I'll need to work around. But 8th, 9th, 10th are all good for me.
Okay. Is everybody in the same boat? Is everybody good, 8th, 9th, and 10th?
EOG is fine.
Yes, Your Honor.
Yes, Your Honor.
Your Honor, this is Alfred Allen. This is Alfred Allen. We filed a motion for Cirrus and Mustang and Sierra Bank that was adopted by Mr. Waymeyer in his 7th motion for summary judgment. And we believe that, and we also supported his 7th motion. So we believe that our motion is set at the same time through his 7th motion for summary judgment and should be considered on the February dates that you're talking about.
Okay, and yes, so whatever we're doing here, anything that's been filed so far that you need to get it set on these same dates, they will be set whenever we get finished. So you can start your deadlines for the responses At the end of
Thank
the
you, Your Honor.
You'll need to settle all the family business on summary judgments that week. Now, I'm very hesitant to just say, well, we'll set it on all 4 days and see how much we get to each day. So what I'm going to do is I'm going to ask everyone to go back into a breakout room just briefly to see if you can work out a schedule on what day or days to do what motions, or even just blocks of time, unless everybody else is in agreement that you ought to just block out your day for 4 days in a row, and with the idea that you're not going to use it all.
Judge, on February the 10th, that Wednesday, we have 13 tax cases set that date, but that's all we have set at this time.
And that's fast.
Okay.
That's fast. So let me open a breakout room again.
Before we break out, Ms. Riley, what is the process for getting our motion set in connection with the way the court is handling the hearing today? Do I contact you separately, or are you currently setting all three of plaintiff's motions?
I mean, if y'all just let me know what y'all want set, maybe put it in chat and I can set it, whatever y'all
Well,
need.
whenever we
set.
get finished, I'm going to ask someone just to type up one page, half page order for me to sign. It says all of these matters are set for whatever date you work out with,
Okay.
or dates. If you can't work it out, then I'll make a decision on that.
Okay. Thank you.
Okay. You should have gotten an invitation to a breakout room.
And then when we are done with the breakout room, do we just leave the room and come back here, or do we just report to you with an order, Your Honor?
Just come back is fine, and or I don't care.
Okay.
If you want to just have one person come back and say you've got an agreed order. I mean, I guess if it's signed off on by everybody, that's great. Otherwise, you probably ought to all come back and make sure that when you read it into the record and say who's going to draft it up, that you're still in.
Thank you, Your Honor.
Okay. All right. So I will be here. Okay, what'd you come up with?
It sounds like we have an impasse.
For the part of the defendant group, we have 8 motions. Number 8 is being heard on January 26th. That leaves 7. With respect to those 7, it's an uncontroverted fact that Mr. Kilday agrees that we were the first party to ask that those be set for hearing. The first discussion about any motions for summary judgment ever in this case being heard was out of us and as to our 8 motions. So we would ask that the 7 that are being continued off of the 26th be set first. The defendant group has no care or concern about what order the plaintiff's motions would be heard. And then along with that, I think DOJ wanted to get its position set and would be fine that being taken in any order. And Mr. Truss lost his connection, but it told me to go ahead without him. And I don't, Mr. Allen, I'm not sure what you and Mr. Grable have in terms of y'all's motion that you'd want to add as well.
Your Honor, what I've urged is that we
Hold on, Mr. Kilday. I think Mr. Allen wanted to speak.
Okay, go ahead.
Yes, thank you, Your Honor. Our motion goes along with about 3 of Mr. Waymire's motions. And so we would like to be heard on our motions at the same time that he is on the related matters in his 7 motions. Plus the 7th motion of his is an adoption of our motion. And we also adopted his 7th motion. So those 2 kind of came together, and we would like them heard as a part of Mr. Waymire's 7 motions that are being heard.
Your Honor, Robert Grable, Fort Worth, for defendants Mustang and Cirrus Minerals, and we were on the same motion as Mr. Allen and his client on those 3 issues, and we are happy to proceed the same way as he outlined on those 3 issues.
Okay. All right, Mr. Kilday.
Yes, Your Honor. What I've encouraged us to do is identify issues that correspond to each other's motions and have those set together and go one by one through the order. Mr. Waymire's indicated he wants all of his 8 motions heard first, and then he doesn't care when other motions are heard. I don't think that's an efficient use of the court's time. And so what I've asked is that we prioritize which issues should be heard first. We believe since plaintiffs filed their motions first, that our motions should be heard first. We asked and attempted to coordinate on getting a joint setting, and we were rebuffed in that. So the fact that theirs were set first without coordination, to me, is of no moment. But that could be something the court could handle on its own. But there are interrelated issues in the release of the Frells lease that's a subject of an EOG motion, a DDR Gaddy Bressler motion, and a plaintiff's motion. So that's a bundle that could be heard together. There are issues relating to and that's the first motion of DDR Gaddy and Bressler. Then there's another issue relating to the production out of the Austin Chalk formation and the formation of a pooled unit in 1982. That's Bressler and DDR Gaddy's third and fifth motions. That overlaps with our first motion that was filed in April, as well as the Sierra Bank, Cyrus Minerals.
All right. So, and I'm not going to be able to keep all of that.
Yeah, that's fine.
Ed. So let me ask the defense counsel, why shouldn't we divide these horizontally so that everybody's motion on one particular topic is heard at the same time?
Your Honor,
this is, I'll let Mr. Waymire talk first if he wants, but just thinking through this and how a judge who's not heard any of this or read any of the papers or been involved in any of the issues, it seems to me that there's first a necessary predicate of a factual discussion of background to get people on the common terms there. And then if we go down with the 7 motions Mr. Waymire set, have him argue them 1 through 7. We can join in on ours 3 when they come up. But Mr. Kilday is certainly welcome then in response to say motion number 1 to then say what issues he has in one of his motions that overlap with motion number one and have kind of a point counterpoint of that, and then go to motion number two, motion number three, et cetera. Because these don't subdivide absolutely neatly where everything in one motion lines up with everything in another motion. So I think there's got to be some logical order of proceeding. And I
Isn't
think
that just what Mr. Kilday just said he wanted to do?
Yes, Your Honor.
No, I think he said he wanted to identify what's in our motion and what's in his motion and talk about an issue. I think the logical order of proceeding is as just to take the first filed motions, argue motion number one, Mr. Kilday that can join in and says, okay, this overlaps with my motion number two, issue number 2A, and our
And that-
response to that.
All right. And I had understood that to be what Mr. Kilday was saying, but if not, then I think Mr. Grable is outlining what I was thinking, so probably more succinctly. So we'll take the plaintiff's motion, the defendant's motions one at a time. Sounds like Mr. Weimeyer is going to be lead counsel. And then whatever number it is, Mr. Kilday, if he has a response or a motion for summary judgment on the same topic, he can argue those along with his response.
And Your Honor, you indicated that the first filed motion would go first?
The plaintiff set theirs, the defendants set theirs first. We'll go with in their order. So who wants to type all that up and circulate it so I can sign it and there's something in the record about what's going to happen on that week?
I had already circulated a proposed order denying the motion. I could tweak that and circulate it to defense counsel, and hopefully we can get to a common understanding. I'm happy to do that today.
Part of their motion was granted, so I don't think this.
But understood. I'll need to make modifications to what I uploaded to the court, and that's what I'm offering to do is modify it to address what the court has actually ruled today and circulate it to all of you for comment.
But I still don't know if there is an agreement as far as, are we just going to start every day and see how far we get and then come back the next day?
Your Honor, so that we don't have any argument over the 21-day notice issue, I think the cleanest thing is that, as the court has ruled, the eighth motion be heard on January 26th, as the court has said.
Right.
The others be taken, all of them be set for hearing on the 8th of February so that we have a 21-day, a clean 21-day calculation and 7-day response calculation, and that there's no arguing over that. And then we would take those up in the order of defense motions being heard first, and in response to each motion as we go through the week, Mr. Kilday can chime in and say, well, I think this goes to my number 3. I want to be heard on that one now. But I would say we notice them all for the 8th and just make good use of our time and try to get them all done but just carry it over day to day until they're done.
Okay, and obviously you defendants would have to then put on their defense at the same time to whatever Mr. Kilday is arguing on his motion. So, okay. All right, that sounds good. If you will, someone will write that up, and I've got to run a couple of errands. I can leave the Zoom meeting running, so you can post that in chat or you can email it to the coordinator.
Your Honor, we'll take a draft at the court's order. We'll circulate it to Mr. Kilday today and seek to reach agreement on that form.
Okay. All right. I will see you next month.
Thank you,
Your Honor.
Appreciate
Have
getting
a good day.
to meet you.